SJC-10590, Commonwealth v. Robert O. Jacobs.
Okay. Attorney Pumphrey.
Good morning, Your Honor. May it please the court, I'm Janet Pumphrey for Robert Jacobs. And before I start, I'd like to thank Clerk Keneally for such a smooth and easy way to get into this new world that we have here. He really made everything perfectly. And I've had other court hearings that don't go nearly like this.
Thank you so much for the feedback. That's great.
Let me start with the three uncalled alibi witnesses. Defense counsel certainly knew about these witnesses. He interviewed them at least once, some of them twice. They were on his witness list. He told them they couldn't be in the courtroom because they would be called to testify. And he introduced them to the jury. Pre-trial, before the trial, he understood the importance of their testimony. In his own words, he said, Vanessa Franklin was the only person who could testify that her brother did not commit this crime. Christina's testimony is going to be very important for the defense. And when the first shots were fired, the defendant and Reeksme were standing together. The motion judge understood the importance. Oh, go ahead.
So let me ask you before you get into what the motion judge said, what did, was Attorney Davis asked about this, the motion for new trial?
Yes.
And what was his response?
For the most part, he remembered very little. The motion judge attributed that to his health. And the way it played out is that Attorney Davis, the two days of evidentiary hearing, Attorney Davis testified on the first day. The second day was months later. It wasn't continuous. And in between the first day and the second day, Attorney Davis had basically very, very little file. I had about 5 documents. Otherwise, it was destroyed in a flood in his basement. Okay. In between the first day and the second day, someone at his office discovered a computerized file. And so I got a good sized file, which we admitted the second day of the motion hearing by stipulation. So the motion judge had this paper file, and the motion judge wanted to call Attorney Davis back to testify to some of these documents. And Attorney Davis, we scheduled it a couple of times. He just was too ill.
Okay.
Yeah.
Okay. But so then you want to, as you were going to address what the judge found with regard to why it was not necessarily a good idea to call these witnesses, considering their relationship to the defendant, correct?
Exactly. And the judge said, basically, he extensively read the extensive notes, and he said there can be no doubt that Attorney Davis went into the trial knowing exactly what the witnesses would have testified to. It's then inconceivable that he arbitrarily threw up his hands and failed to call them. And I would suggest that's exactly.
Can I ask one question about, it's Vanessa, right? She's
Vanessa.
So she said she drove to the party with the defendant, and we know from the victim's girlfriend that that's not true, right? So we had one contradictory fact right up front. Is there, by the way, is there any evidence besides the other sister that Vanessa was at the shooting? Is there evidence that this isn't all made up, or?
I can check the record. I don't remember other evidence.
Well, counsel, dovetailing off of that, my understanding is in the record, there wasn't any evidence that Vanessa was at the party, right?
I'm not remembering any evidence. Perhaps my sister remembers more than I do, but I will check the record.
Okay, that's a real
because wouldn't that be a big deal?
Well, if they completely made it up, but I would suggest they were very credible, both of them.
Well, the second sister adds very little. The second sister doesn't add much to it.
She doesn't. She just corroborates.
It's really Vanessa and I'm going to mispronounce the other gentleman's name.
Reeksme.
Yeah. But again, so no one places, when we go through this record, and I have not read this record yet, are we going to have any, you think because if there's an issue of whether she was actually there, then you understand why Mr. Davis, who's a very skilled trial lawyer, doesn't want to go anywhere near that, right?
Yes, but he interviewed her two times, is my memory, Vanessa, and she told him, and he says he told her your testimony is very crucial because you're the one person who says your brother didn't commit the crime. Attorney Davis believed her.
Well, we believed her. He wrote down what she said. You know,
That's true. That's true. her testimony was important because she's the one person who could say this. There could be no better defense than a witness who says that the defendant was not the shooter.
Well, but counsel, that's not necessarily true when your witnesses are related to the defendant.
That's
and
true.
You have like 1, 2, 3, almost 4, as I count them, people saying it was the defendant that are not.
Well, it was really just Sawyer Key.
But Jacqueline saw him fire 2 shots, right? Maybe up in the air, and Carmen sees the gun. And Jean-Pierre identifies him as the shooter. And then you've got Toby, who delays it a little bit because he's afraid, and then he wouldn't go further in court. But so you do have a substantial body of witnesses saying he is the shooter.
Well, you've got a couple of people who say that the shooter was standing in the middle of the hill, shooting up the hill. And those 2 people couldn't possibly be correct or telling the truth because the shooter.
That's based on your expert witness, right?
That's exactly right. That's exactly right.
But your expert doesn't deal with Sawyer.
No.
Because according to your expert's conclusions, Sawyer's testimony would be consistent with what he claims, how far away in the plane that the victim was shot and killed with, right?
It would be, her testimony is it's difficult because there were a whole lot of things wrong with it. She testified basically that she didn't say what they said she said, that she didn't remember anything at all. The officers put words in her mouth. She didn't circle the picture. She didn't identify the picture of the defendant as the shooter, but only that's who that was.
Yeah, but we can see what that was, right? I mean, after the fact that we could see what this was at the time of trial. My concern is trying to look at this case within which you're saying that Attorney Davis should have called these people. And the language that you're relying on was a letter that was written to her prior to trial, right? About her importance. But then the trial unfolded, and like a lot of things unfold a way that perhaps illuminates what you might have thought before. And didn't Attorney Davis say to the trial judge why he was not calling these folks?
Well, sort of. I mean, he basically said they didn't have anything to offer. And then he made some, I think, perhaps trying to be humorous statements about how the 2 district attorneys would tear them apart or something like that. And I think that was an attempt at humor, or at least that's what the motion judge thought as well. But there really was no reason not to call them because they were right there willing to testify. And if they refuted what the other witnesses said, at least put on a defense. They were friendly witnesses.
Counsel, let me ask you, did you run their background? Did you do background checks on these witnesses before making the determination they'd be good to call? I mean, he may have.
I didn't myself, but I think that Attorney Davis did.
Kind of known that, I mean, he thought they would be torn apart by the Commonwealth.
Well, yeah, that's hard to say. The only one, I mean, Vanessa and Christina, I don't know for a fact, but I believe had no criminal record whatsoever. Rigsby had, there was, I don't know what kind of record he had, but there were inconsistencies in his police reports for sure.
And Rigsby only gets you up the first 2 shots. He doesn't.
That's exactly right. That's exactly right. Vanessa's the crucial one. The Commonwealth's theory was that the person who shot the first 2 shots was the same person as the shooter. So Rigsby definitely helps in that regard.
Can I ask you a question just on the facts? Was
Sure.
Vanessa saying that the defendant was with her during the first 2 shots, so that it would have contradicted Rigsby?
No.
I thought she was saying that she left the party with the defendant at midnight.
That's right, but I think that's after the first 2 shots. It was a little confusing, but Rigsby was with the defendant standing in the parking lot for the first 2 shots. Then Vanessa and the defendant walk up the hill on the far left hand side to the Cumberland Farms where Christina picked him up.
Is Rigsby's testimony consistent with Vanessa's on the first 2 shots?
Yes.
It is. Okay.
Yeah. The finding, the motion judge found that Attorney Davis had tactical reasons for not calling these witnesses. But I would suggest that reasoning is that finding is clearly erroneous. For one thing, there's really very little evidence that supports. I mean, they would have made good witnesses. They were credible. They would have refuted all the other testimony, which actually was not much, and it was certainly all over the place. And I would suggest that if
Well,
this
with that, Ms. Pumphrey, if the testimony is all over the place, is Mr. Davis making a bet that, it's such a mess that that's the best place to go here? I mean, we have to evaluate that, right? I mean, I haven't read all these transcripts here. But when we read them, is it going to be a mess?
Well, they are all over the place. The two that testified that the shooter was standing in the middle of the hill, that just wasn't the way it played out. From Carmen Velasquez's testimony, the shooter was, and also the crime scene reconstruction, the shooter was at the very top of the hill behind Carmen and the victim, and shooting sort of down towards basically behind the victim, because he was facing the party house and she was facing North Street. And the crime scene reconstruction said that experts said that the shot went into his back from an upwards to a downwards, which would put him behind and above. So it's a little different.
So if that's an accurate representation of the record before there was an opportunity to put on the defense, why was it manifestly unreasonable to just say, it's a mess? You have to throw it beyond reasonable doubt and rely on that, as opposed to trying to put up an alibi, which might have, some problems in terms of credibility, especially with Richme.
Well, I would say that putting on no defense at all, when the witnesses would have testified and refuted a lot of what was said, it makes a whole lot of sense to have witnesses who testify, that the defendant was not the shooter, that he was someplace else.
We're looking at that the test is manifestly unreasonable.
That's right.
I guess
That's right.
to get beyond it's a 50-50 shot,
right.
you have to
That's
show
right.
that it's manifestly unreasonable. Why is it?
Well, it's manifestly unreasonable test is a search basically for the rationality in the decisions, taking into account all the circumstances known or that should have been known by counsel. And if you go to his notes, which are not extensive, but the stipulation of the parties, if you go to his notes, he tells you exactly what he knew, and these were important witnesses, and he knew it. And then he just failed to call them for.
Right, but counsel, the motion judge, not only did he note that they were family members, he also noted that Vanessa had a lack of memory about the party and who was there. That she told an investigator working for Attorney Davis that she rode with the defendant to the party, but that conflicted with her testimony at the motion hearing. And that Richme's testimony, the defendant was next to him when the first set of shots went off, would conflict with Vanessa's testimony that she was with the defendant after they left the party. And so, and it goes on, but it seems like to me that when you say the definition of something being manifestly unreasonable, you look for the rationale that makes this okay. This seems very legitimate to me.
Well, I think that all Attorney Davis knew before trial was what he learned from the witnesses' interviews. That's what he knew, and it was the language in the.
But do we always measure everything with regard to what the lawyer knew before the trial, or do we take into account the lawyer, what's in the lawyer's file? I mean, the investigator and all those other things.
Well, I think in this case, the attorney's file is important because Attorney Davis had so little memory at the Rule 30 motion, and the motion judge really tried to get him back on the stand so he could ask him some of these questions, and he just was too sick to come. So. So the file is important because it's exactly what he knew at the time of trial and exactly why he made these decisions.
But they're reasons. They're reasons for the decisions. Sounds to me like you disagree with the reasons.
Yeah, but he also goes second. If he's going to put on any evidence, he goes second.
That's true.
So what you know before trial and after the Commonwealth puts on its case in chief really then may inform whether you really ought to do what you thought you should have done pre-trial. It's aqueous. So I'm just trying to find if you're saying that if your only shot is putting on witnesses who have a variety of warts, that would then be decimated on cross-examination and have absolutely zero credibility to the jury, that it's manifestly unreasonable to
Mhm.
not put these folks on the stand anyway. Is that what you're
Mhm.
saying?
I am, because the warts that you're describing were not huge warts, in my opinion. They were, just because they're family members, they were credible, and just because they were slightly confused, which we know now after we've heard their testimony, they were a little confused.
Isn't it a pretty big wart that she says she went to the party with him, and the sister of, I don't know how to pronounce his last name, Rexmay,
Freaks me.
said he's the shooter and we all drove together. And Vanessa was not in that car. Isn't that a pretty big wart to then have to credit that she was with him the entire time and away left the party? Isn't that a pretty big hurdle to overcome, credibility wise?
I would have thought that Attorney Davis discussed the inconsistency with her. He
But
was absolutely.
Doesn't he also, Attorney Davis also asks her, look, I need somebody else at that time frame, right? He asked Vanessa
Mhm.
to find somebody else who was with her and the defendant as they went up the hill, right? And she doesn't get him anything, right? No, so
You're talking about Christina.
no, I thought that Attorney Davis asked Vanessa, saying, look, it's very important for us to find a non-family member who's going up that hill with you too.
I don't remember this. Okay.
I thought that, I may have made it up, but I thought it was in in either the briefing or in the motion judge's decision that Attorney Davis didn't just leave it to her. He wanted sort of a test of.
Well, my memory is that Attorney Davis asked, and I forget if it's Christina or Vanessa, to find Reeksme.
That's
Because
a separate issue. I remember that one.
Okay.
I believe I believe that he made the point to Vanessa that we need somebody besides you.
I don't remember that, but I'll look for it. Okay.
Mhm.
And I guess, well, the point of this with Reeksme, and I think that this is important, that counsel's reasoning for not calling him really had nothing to do with any of the conflicting police reports. What he said was at the Rule 30 motion, I can say with absolute certainty that I did not consider calling him as a witness because I did not think he was going to testify to anything useful. And when just before trial, he recognized the importance of that testimony for not calling him, because he was the one person who could say, who could give him useful information. And it's manifestly unreasonable, in my opinion. Also,
can I ask, the judge has sort of an extra it seemed unusual to me. The judge asked Attorney Davis at the trial, so you're not bringing it. So he presents that to Attorney Davis. And then he says those two vicious, women prosecutors are gonna, but so it's not as if we sort of know it. The judge raises the issue with him. Isn't it clearly tactical at that point? The judge is making sort of an unusual step of asking him to articulate why he's not presenting the witnesses. Isn't that unusual? And don't we give some credit to that in terms of whether we've got a tactical decision here?
Well, I think with respect to Attorney Davis at the Rule 30 hearing, he really remembered.
I'm not talking about the Rule 30 hearing. I'm talking about a trial, right?
A trial, okay.
Trial, doesn't the judge ask Attorney Davis, you're not bringing witnesses? I mean, the judge is.
The judge is giving him every opportunity, yes.
Giving him every opportunity, but does that relate to whether, Mr. Davis has made a tactical decision at that point that the judge is like questioning him about it, and he says, I don't want to expose I don't want to put these two women on the stand and have them torn up,
Well, I would just suggest that the judge may be saying this because he thought that the witnesses should be called. Attorney Davis has got these 3 witnesses there, and he doesn't call them.
Can you remind me, did the judge ask the defendant as well?
The judge did ask the defendant as well. And there was a sort of a brief colloquy, and the defendant basically said, his lawyer tells him he's talked to his lawyer, and his lawyer says, I don't want to call him with respect to Reeksme, only Reeksme. And so the defendant did say that, but the defendant is an uneducated young man who had really never been in trouble before, is my memory. But importantly, after both the motion judge and defense counsel himself said that the defense counsel's decisions may have been wrong in hindsight. And Attorney Davis says, hindsight tells me that Reeksme should have been called. With respect to Vanessa, if she had been with the defendant at any time when the shots were heard, it would have been helpful to the defense. So basically he's saying,
you notice the word if, and what you just read had the word if in it.
That's right. That's right. But
odd formulation given.
let me see if those are exact words. He did say that. But I think there was, go ahead.
Further questions?
No, thank you, Chief.
Okay, thank you very much.
Thank you.
May I please the court, Carolyn Burbine for the Commonwealth. It's our position that defense counsel was not ineffective for failing to call these witnesses, and that the judge who reviewed it properly found that this was a tactical decision, and the record supports that. We have Attorney Davis right on the record contemporaneously at the trial telling the judge, I'm not going to call any witnesses in view of the testimony of the other witnesses to the effect that Mr. Key was observed along with others, including the defendant, near his car at the time of the first shots. He didn't know what else he could bring to the table. He also said he was reluctant to expose him to the cross-examination from the prosecutors and calling them, calling it vicious cross-examination by these two young ladies. That Judge Cosgrove recognized that as an affectation of Mr. Davis, but that doesn't mean that he wasn't concerned about cross-examination. And then regarding Vanessa and Christina, he said they will not be utilized because after hearing everything I've heard, I don't think they will bring anything to the jury that would be helpful.
I know hindsight's always better, but I'm just trying to figure out, again, I haven't read this whole record. But if it's really damning and we've got, and you've got a witness who says, I was there the whole time and he didn't do it. It gets a little tricky not bringing that witness, especially when you've sequestered them, you've told everyone they're coming and
right. Well, if you see, he also said at the motion hearing, and he did struggle greatly. It was very sad, but he said, as Judge Cosgrove noted, with great conviction, if he decided not to call someone, he had a good reason.
That's just habit. Can I ask, do we have any other evidence whether Vanessa was at that party?
No.
This record? So we don't know.
And I think that's important here. She claimed she was at the party, but then she testified at the motion hearing. She didn't know the hostess. She claimed to know a few people. The record shows that Attorney Davis was concerned. He asked her to give him the names of some people she knew there, which would show he was concerned about cross. There's no indication she ever did. No one testified at the trial that they saw her. And as Judge Cosgrove noted, significantly at the motion hearing, when Reeksme was asked if Vanessa was there, he, quote unquote, exhibited a rare moment of indecision. That's what Judge Cosgrove noted, and said he was not sure. And then he claimed that he thought she was, but he didn't remember seeing her. So I think it's very important that there's a serious problem there. And then on top of that, we have the fact that she has this very important information, but she admitted she never went to the police, never told the police any of this.
How about
and I think that's important.
How about
the alibi information to give it in a timely fashion?
How about the expert issue? So we have sort of one witness who sees the defendant shoot the victim, right? And she's close by, but the other witnesses are describing shooting from down the hill, which can't be true, right? So they're clearly wrong, right? Because the 5 bullets are found, the 5 shell casings are found within 5 feet of the victim, right?
Right.
So wouldn't that have been helpful?
Well, if you look at Vanessa's, are you talking about Vanessa's testimony in that regard?
No, I'm talking about the expert witness on ballistics.
Oh.
Showing that the 2 people who said that they saw firing from down the hill are almost surely inaccurate.
Well, we
because-
really only, when you read the transcript, you'll see that there was really only one who definitively said the defendant was in the middle, and that was Aaron. And Attorney
It wouldn't-
Davis in his closing discredited Aaron by saying that, he wasn't a reliable witness. He was a young kid. I think he tried to get around that.
In answer to Justice Kafker's question, can you tell me how accurate was this expert in his conclusions? How much confidence was there? Was he impeached on cross-examination? What happened?
Well, Judge Cosgrove found that Massey, basically relied on all of the measurements by the police. He didn't contradict the measurements, didn't contradict the ballistician. He opined that the victim and the shooter and the gun were on the same plane. Judge Cosgrove held that Massey didn't contradict the heart of our case, which was Sawyer's testimony. She had told the police, obviously when it was fresh in her mind, that she was with Carmen and the victim when they found each other on top of the hill. She started to walk down. She heard the second set of shots. She quickly turned around. She saw the defendant shoot the victim in the victim's right side. Judge Cosgrove also noted that at the time that the defendant fired, she said that the defendant and the victim were 5 to 6 feet apart.
Do we know
which
how
was a
big
distance.
this hill was? Do we have any measurement on?
No, there are 2 exhibits. And as Judge Cosgrove noted, there is a 160-foot measurement, but when you look at it, that is not from the top of the hill to the bottom of the hill. No one actually measured the hill itself.
Okay.
And you can see that there's actually, in one of these, you can see that, in one, you have to look at both of them in conjunction, but there's
the prime
grassy-
witness.
I'm sorry.
The prime witness, doesn't she, at trial, she says none of this is true, right? She walks back everything, right?
Right.
So,
And
again, if the ballistician expert could have undermined all the other IDs, you're left with one person identifying the defendant who now has said, none of it's true. So there's no value to that. I mean, that's.
Well, I don't, the measurement, according to the defendant, it's physically impossible for the defendant to be the shooter unless he was up at the top of the hill and witnesses saw him in the middle. I would dispute the account of Jaron McNeil and
But don't they put him down the hill, right? The only person, you've got hard evidence that the guy shot at close range, right? You got the 5
Right.
shells. Unless the guy is a marksman, he's nailed him from pretty far away. So I guess this ballistics evidence seems to be fairly useful here, because it could limit you to one person identifying the defendant as the shooter, and that person's walked back everything she said. So,
but she's walked it back because she said she's had conversations with her brother, who is the defendant's friend. And then we have all of Reeksmee's problems as a witness. And
I'm just talking about
biased.
her. I understand she tells the cops earlier that he's the shooter, I was right there. But then she's completely recants her testimony at trial, right?
yes,
Even though
but
she's facing a perjury conviction for doing so.
right. But she's also said that she's had multiple conversations with her brother, and we can see from Reeksmee's testimony at the motion hearing what his issues with bias are, where he gave like there are at least 4 instances that I cited where he where he gave different
So
versions.
what is the standard for the new trial, though? I mean, are you putting too much of a burden on this expert? Doesn't it just have to be a real factor, or what is the standard?
Well, I think the decision not to call him has to have made a difference at the trial. I mean, it had to, if I
Oh,
just,
so
I
you
just want to do.
got an expert, you got an expert that will undermine everybody else, and you've
Well, it has
got
to be substantial ground of defense. It has to provide a substantial ground of defense, or it was necessary to rebut critical expert testimony put on by the Commonwealth. And as Judge Cosgrove found, Massey's testimony didn't contradict any of the police finding. It's what the defense has tried to extrapolate from it. It's our position, it's erroneous. The defense has tried to say, well, he says it was 160 feet. That's the measurement of the hill. People who said he was in the shooting was in the middle, that had to be 80 feet. That's not accurate on what Massey said, or what the measurements were, or what the exhibits show. So it's overstating, what he said. And basically, if you take what he really said, the meaningful stuff that he said, it was that the shooter and the victim were on the same plane, and that is supported by Saurier's testimony. And I also dispute the characterization of Jaron and Shaquan saying that it was the middle of the hill. If you look at the transcript, and Judge Cosgrove also found this, Jaron said he heard the second shots when he was jumping a little hill. He heard them like in the middle of a hill. So he's not saying he saw anything. He's saying that was his impression. He heard it. He could not see where the victim or the shooter were. Shaquan said he was beside Jaron. He heard shots fired from behind him as they were about to jump a fence. He testified he didn't see the victim or the shooter. So he gave no opinion of whether it was in the middle of the hill or elsewhere. So Aaron was the only one to testify to that. And then we have Saurier, who.
How many people, when we go through the transcript, how many people saw the defendant with a gun? How many witnesses? And was anyone else spotted with a weapon, this thing?
There was no testimony about a second weapon, but the ballistician could not say definitively, because no gun or guns were recovered, that there definitively had to be one weapon, although he opined that the casings were all likely shot from the same gun. He could not definitively say that. I'd also point out no one, I'm sorry, so Carmen said she saw the gun in the van. Jaron said he saw it when the defendant lifted up his hoodie in the basement. Carmen confirmed that encounter.
And the bullets are what? I can't remember what caliber weapon this is.
They're all 380.
And was there any matching of the gun spotted in the car as being consistent with that?
There was testimony that a small gun, Carmen had described it as a little gun. There was testimony that a little gun could, 380 could be a gun that could fire 380 cartridges could be a small gun.
Counsel, could I change gears for a second?
Yes, sure.
Could you talk to me a little bit about the issue with the jurors? Because the concern that I have here is the trial judge gets some indication that it was more than just these three jurors that were involved in this. And yet there was only real inquiry done with those three folks, but it seemed to suggest a couple of things. One is that the discussion about reasonable doubt the day before involved many more than just these three people. And then the other concern that I have is, even if you credit the two that were ultimately dismissed, it would seem to suggest that maybe the foreperson wasn't being completely forthright with the court about not only the involvement or the encouragement to look into this, but with all this going on, isn't this why wasn't a mistrial the appropriate remedy in this case?
Well, the system, the method of looking into this is to question each of the jurors, which the judge did. She followed the procedure, and what her job at that point is to assess their capacity to restart the deliberations and reach a verdict independent of any extraneous materials. So She's supposed to do an individual voir dire on the extent of the exposure and the effect it had on each juror. And then she has to decide whether to declare a mistrial or whether there's a less drastic solution. And so what she did was she called the foreperson in first. And, the foreperson told her that when she walked in the room, she saw Burke writing the information. Foreperson told her she was uncomfortable with this. It told him she was uncomfortable that it needed to tell the judge. Court officer then came in.
But this is that day. This is the day of when the court officer made this discovery. I want to go back to the day before, because
Okay.
the information seemed to suggest that this was prompted by the foreperson in discussions about this instruction amongst more than just these three folks. That there seemed to be a suggestion that it was more jurors than this that were part of this conversation.
Right. So the day before, but they haven't, I think it's important to note that they have not yet begun discussing reasonable doubt. They know that they're going to talk about it the next day. So they haven't begun talking about it. They've been given the instructions. And then, there is a discussion about the next day. So Burke said, and he's the one who's writing everything on the paper, that no one else saw what he was writing. She calls the foreperson in, and the foreperson, says she just saw the heading and the next thing. Then Van Warmer, who's another problematic juror, she's the one who says at the end of the prior day, she suggested that the jury discuss reasonable doubt the next day. She claims the foreperson suggested that she look it up and that she went home and did what she did. So the judge appropriately recalls the foreperson, and the foreperson acknowledges that she told Burke when he said he wanted to consult the legal search, if you're going to do that, the source had better be the legal one. But she said she didn't suggest everyone go and do it. And when she was asked if she suggested they look at dictionaries, she said she didn't think that she had said that. The judge explained why she didn't excuse the foreperson. She said it was because she didn't exercise leadership that day before. She didn't handle it well the day before. But while she didn't act correctly, she didn't violate her oath. When Burke came in, which was actually going to be the problematic time, she did the right thing and sought to notify the judge. And that indicated to the judge that she could carry out her duties responsibly. And then the judge had questioned her, can you follow my instructions? Can you in the future? And the judge credited her testimony and found that she was indifferent. So at that point, the credibility determination is for the judge to make when he's seen and heard a witness. And so, then you have to look at, well, what did everyone see? And, while they may have overheard that discussion, only those two actually acted on it and looked up anything. Those were the offending jurors. They were dismissed. Everyone else was asked what they had seen. And at most, the only thing they had seen was either reasonable or reasonable doubt on the top of the paper. And they never saw the definition. So that extraneous influence was limited to a title at most. So that would not warrant a mistrial. The judge chose an appropriate remedy, which was within her discretion, and that was to dismiss the two offending jurors after she had questioned everyone and made sure that they, that the effect had not been any kind of taint on their ability to continue reformed with the new alternates starting fresh. And that would cure any error, any problem from it.
Okay, does anyone have any further questions?
Oh, thank you, Chief.
Okay, thank you very much, counsel.
Thank you, Your Honors.
Justices, Judicial Court, now sitting at Boston, within the Commonwealth. President Park, sitting in this court, is now adjourned. Not saying the Commonwealth of Massachusetts.